Hello, everyone. Welcome to Lecture 2 in the Insurance Law Lecture Series entitled Insurable Interest. In general, an insurable interest is that interest which a person is deemed to have in the subject matter insured, where he has a relation or connection with or concern in it, such that the person will derive pecuniary benefit or advantage from the preservation of the subject matter insured, and will suffer pecuniary loss or damage from its destruction, termination, or injury by the happening of the event insured against. If the insured has no insurable interest over the life or property he insures, the insurance contract is considered unenforceable. If it can be established that the contract is really a wager, the same can be considered void for being against public policy. Every person has an insurable interest in the life and health of himself, of his spouse, and of his children, of any person on whom he depends wholly or in part for education or support, or in whom he has pecuniary interest, of any person under a legal obligation to him for the payment of money, or respecting property or services of which death or illness might delay or prevent the performance, and of any person upon whose life any estate or interest vested in him depends. Where a debtor in good faith insures his life for the benefit of his creditor, full payment of the debt does not invalidate the policy. In such case, the proceeds should go to the estate of the debtor. Meanwhile, in a situation where an insurance is taken by a creditor on the life of his debtor, the insuring creditor could only recover such amount as remains unpaid at the time of the death of the debtor, such that, if the whole debt has already been paid, then recovery on the policy is no longer permissible. Every interest in property, whether real or personal, or any relation thereto, or liability in respect thereof, of such nature that a contemplated peril might directly damnify the insured, is an insurable interest. An insurable interest in property may consist in an existing interest, an inchoate interest founded on an existing interest, or an expectancy coupled with an existing interest, in that out of which the expectancy arises. A mere contingent or expectant interest in anything not founded on an actual right to the thing, nor upon any valid contract for it, is not insurable. The measure of an insurable interest in property is the extent to which the insured might be damnified by loss or injury thereof. Insurable interest in property exists in any of the following cases because the person is so situated that he will suffer because of the loss due to a peril insured against. 1. When the insured possesses a legal title to the property insured, whether vested or contingent, defeasible or indefeasible. 2. When he has equitable title of whatever character and in whatever manner acquired. 3. When he possesses a qualified property or possessory right in the subject of the insurance. 4. When he has mere possession or right of possession. And
Hello.
lastly, when he has neither possession of the property nor any other legal interest in it, but stands in such relation with respect to it that he may suffer from its destruction, loss of a legal right, dependent upon its continued existence. Now let's tackle the distinctions between insurable interest in property insurance and life insurance. As to extent, insurable interest in property is limited up to the value of the property, while insurable interest in life is unlimited except if secured by the creditor. As to time when it must exist, insurable interest in property must exist at the time of perfection of the contract and at the time of the loss, while insurable interest in life must exist at the time of the perfection of the insurance contract. As to need for legal basis, in insurable interest in property, expectation of benefit must have legal basis, while in insurable interest in life, expectation of benefit need not have legal basis or need not be based on legal enforceable obligation. And lastly, as to beneficiary's interest, in insurable interest in property, beneficiary must have insurable interest, while in insurable interest in life, insurable interest is not necessary if the insured took out the policy on his own life and designated another as beneficiary. Beneficiary must have an insurable interest if he is the same person who took out an insurance on the life of another. Finally, let's talk about subrogation, where a mortgagee insures the mortgaged property at his own expense and for his own benefit, and a loss occurs. The insurer, on paying the loss to the mortgagee, is subrogated to the extent of the amount thus paid, to the means of enforcing payment of the original obligation by the debtor, the claim not being extinguished until payment to him. However, where the mortgager obtains an insurance on the mortgaged property, or the insurance was obtained at his request and expense, the insurer is not entitled to subrogation to the rights of the mortgagee on a payment of the loss in the absence of a specific provision thereof in the policy. So that's it for today's lecture. Thank you so much for listening.